Hi, everyone. My name is Shana-Tara O'Toole. I am the founder of the Clause 40 Foundation, named after the part of the Magna Carta in which the promise of due process that America's legal system is based on was first written down in the 13th century. Clause 40 Foundation is a nonpartisan 501c3 founded on the belief that the promise of justice in our Constitution is still unfulfilled in our modern society, and that failure is preventing the advancement of this country and all of its people. We believe the erosion of procedural due process rights is one cornerstone of the problem, and therefore our mission is to rebalance the nation's criminal legal system by preserving the due process rights guaranteed in the Constitution through public education, events, research, litigation, and advocacy. While other voices are shouting at each other across a void of misunderstandings and mistrust, we are working to bridge the divide, partnering with all communities to move America toward justice. I'm also the founder and president of the Due Process Institute, our sister organization, a 501c4 organization that lobbies to change the criminal laws and policies of this nation. Thank you for joining us for this evening for part 2 of our series, in which we explore how to transform prosecution. We are offering free advanced screenings of Philly D.A, a new 8-part docuseries from Independent Lens and ITVS before you can watch it on PBS, and then followed them by panels of experts to discuss the main topics that arise in each episode. We will be missing next week in recognition of the holiday, but we return on Sunday, April 11th with our next episode. And then again, each Sunday after that until we are joined by Larry Krasner himself on our final episode on May 16th. So we do hope you join us for more of these. And don't feel bad if you need to miss one. Each episode really does stand on its own, so you don't absolutely have to see the last one in order to enjoy them all. You can register for each of the remaining episodes by visiting our website, clause40.org. Before I introduce our panelists for this evening, I'd like to note that Clause 40 Foundation does not participate in or intervene in any political campaign on behalf of or in opposition to any candidate for public office. The Philly D.A. docuseries from PBS, ITVS, and Independent Lens concerns one particular office's prosecutorial approach, and we are presenting it to the public as part of an education campaign on transforming the prosecutorial role to ensure a fair and more effective criminal legal system. Any particular panelist's involvement with our program should not be inferred as support of or opposition to any particular candidate for office unless they explicitly state otherwise during their participation. We're lucky to be joined by 4 terrific lawyers tonight. First, let me introduce Lisa Wayne, whom I'm lucky enough to know for many, many years now. Lisa Monet Wayne is an attorney in private practice in both the state and federal courts across the country. She handles serious felonies and complex civil litigation, including numerous high-profile cases. Previously, she was a Colorado State Public Defender for 13 years, where she served as office head, training director, and senior trial attorney. She lectures nationally. She teaches all over. She serves as a legal analyst for numerous media outlets. And importantly, she is my favorite past president of the NACDL, the National Association of Criminal Defense Lawyers. I can say that, right? I can say you were my favorite. I mean, there's been a lot of good ones, but you're my favorite. Rebecca Brown joined the Innocence Project in 2005 and directs its federal and state policy agenda. She has also served as a policy analyst for the mayor's office in New York City and a senior planner at Center for Alternative Sentencing and Employment Services, where she conducted research, evaluation, and planning work around its alternative to incarceration programs. Rebecca began her career at the Civilian Complaint Review Board, where she investigated allegations of police misconduct for the city of New York. She's smarter than almost anyone else I know. She works harder than almost anyone else I know. And I promised her a good whiskey for giving up her Sunday night for us. So thank you. Kevann Gardner has worked as a criminal defense attorney for over 9 years. He began his career as a public defender at the Legal Aid Society in New York City, serving as a trial attorney in their Bronx office. Kevann is currently a supervising attorney at the prestigious Public Defender Service for the District of Columbia, where he has worked since 2014. He was born and raised in Detroit, Michigan, but hopefully he's here to stay in DC. Welcome, Kevann. And last but not least, I've asked someone very special to moderate this panel for us tonight, Blair Brown. Blair is a partner at Zuckerman Spaeder, where he represents individuals and entities in a wide array of sophisticated criminal and civil litigation matters. But he spends a significant amount of his time, both work time and non-work time, on pro bono work. In his pro bono legal work, Blair has represented inmates on death row, written appellate amicus briefs on significant issues of criminal law, and provided legal ethics advice to public defender organizations. Before joining the firm in 1988, Blair tried serious felony cases as an attorney at PDS and recently served as chairperson of their board of trustees. He has previously served as a founding board member of Gideon's Promise and is co-founder and former chairman of the board of directors of the Mid-Atlantic Innocence Project. We are also very lucky to have him as one of our board members here at the Clause 40 Foundation. And he has very graciously agreed to join us tonight from a secret location off the coast of Louisiana. Blair, thank you all. Take it away and have fun.
Thank you very much, Shanna. Those were very nice introductions. This was a very interesting episode, and of course, one of the principal issues, the issue that we're going to center this discussion on, is the dilemma that was presented to the prosecutor's office, call it a dilemma, about the extent to which and the manner in which disclosures are made to criminal defense lawyers of instances of prior police misconduct by witnesses who are police officers in particular cases. So I wanted to kick this off by setting the table with a discussion about what the legal obligations are for a prosecutor to disclose to the defense prior misconduct by a police officer who will be a witness in the case. And any of our three panelists are welcome to kick that off.
Well, I'll start because it was so fascinating, Blair, to watch what was going on in that office. And, you know, the legal standard varies from state to state, from courtroom to courtroom, from state to federal court. And my position has always been that it is an ethical and a moral obligation that forces the prosecution to have to disclose what can be the center of any case. The credibility of witnesses in every trial is important, but the credibility of those who are prosecuting and law enforcement who are an integral part of any prosecution goes to everything that we know in terms of trusting the system. So there are certain laws that say Brady and discovery, exculpatory evidence, all of those things can be important. But again, to me, it is your ethical and your moral obligation to prove beyond a reasonable doubt in the way that you should, and that means disclosing to the defense. So that's why I think so many of us are proponents, and Rebecca's shaking her head and says, come on, that we got to have open file discovery. Open the file, show us what's there. Let us question the credibility of everyone, including the officers involved in the case.
Rebecca, you see these Brady issues really all around the country in your work through the Innocence Project. What have you seen as some of the more significant developments in this area, really as a matter of policy, in recent years?
Sure. I mean, I think in recent years, it's been the passage of some state-based open file discovery laws, like Lisa was just describing. So, and interestingly, two that I can think of in North Carolina and in Texas really got sort of political life because of wrongful conviction cases, the case of Alan Gell in North Carolina and the case of Michael Morton in Texas. You know, that's what really sparked, you know, the public's interest in this issue. I mean, I think it's an interesting policy issue because, you know, it's not the thing that always jumps to mind as like, you know, in the era of, you know, really trying to shrink the mass incarceration footprint, you know, discovery doesn't always come up as necessarily the most sexy policy issue, but quite frankly, it is foundational. And, you know, and we know at the Innocence Project that 11% of our DNA-based exonerees, these are people convicted of rape and murder, the most serious crimes, 11% of them pled guilty to rapes and murders that they did not commit. So it's incumbent upon states not just to pass open file discovery, it has to be pre-plea discovery so that this is information that the defense has so that they can properly advise their clients in advance of, you know, potentially a trial or a plea, I should say.
And Kevann, have there been developments in DC that in the area of Brady and more specifically disclosure of police misconduct in recent years that your work as a public defender at the Public Defender Service in DC has revealed?
Sure. It was very interesting watching the video because in DC we have this fight all the time, and we've really been pushing to get this information, to get any documents pertaining to police misconduct. And to see that they had a no watch list in Philly was very interesting because, as Lisa said, it's kind of different wherever you are, the rules and what the practices are. In DC, if the prosecution is going to call a witness, that is the only time you can ever get any type of documentation pertaining to police misconduct, which means that there could have been a number of officers that actually worked on an investigation, were directly involved in a case, and we have no access to any misconduct information that may pertain to those individuals that worked on the case. And that's very frustrating because, as you saw in the video, what the prosecution does is they pick and choose which police officers they want to put on the stand. And those are the only officers that we can attempt to get this documentation from pertaining to police misconduct. So they effectively hide the officers that may have problematic things in their past as a way to not turn it over to the defense. And if they don't call that officer as a witness, we literally have no way to get that information. So in DC, it's not even that they have a no witness list. It's that, that list of officers exists, and we know they exist, both the prosecution and the defense. We just don't have access to it. And the judge never forces the prosecution to turn it over. So and people think of DC as kind of a liberal hub and a place where these things are less likely to happen. But even in Washington, DC, it happens on a daily basis in every case that you have.
Well, one of the obstacles that Krasner's office was facing was here you had a prosecutor who actually wanted to disclose information or wanted to consider whether to call these police officers, and he couldn't get access to the information. And I don't think that's unique to Philly. I mean, I'll ask the question first. I mean, does the prosecutor in a particular jurisdiction have an obligation to get that information from the police department to the point of actually asking the court to order the police department to produce it, or through some other means to make sure that he or she is confident that they have the information? Because as we know, the Brady rule considers information that is in the possession of the police and in possession of the government, more broadly speaking, the prosecutor's office as well. So, there were real barriers there. It's actually not a subject I've thought a lot about before I saw the video, but I'm curious whether others have had knowledge of or experience with prosecutors having trouble even getting the information.
It's absolutely true. I mean, in New York State, for instance, just in June, for the first time after decades, we were able to repeal a longstanding labor law that had kept police disciplinary records private. They were entirely confidential in the state of New York, as they are currently in the Commonwealth of Pennsylvania. And, we even had an assistant DA out of Manhattan office say, we need this information. We don't have access to it. We can't even assess the integrity of the cops that we're putting up on the stand. So there are a lot of laws in this country. In fact, only, I think 10 states to 13 states have publicly available police disciplinary records. Most of the states are either entirely confidential, like the Commonwealth of Pennsylvania, or restrictive in some manner, very restrictive because of union contracts and other roadblocks.
I think Rebecca's being kind to the prosecutors, because here's my feeling about it. I feel like it's kind of this don't ask, don't tell. So you got prosecutors who are saying to me, I'd like to know. And I really don't believe that. And, it was interesting to watch some of these prosecutors in this film being very frustrated by the fact that the cops are not disclosing this to them. And I felt like saying, welcome to our world, because this is what we've been doing for, how many years have we been asking for this? And every defender, in our offices, we have these, motions for discovery. And I want the triple IB files, which are the inside information files of the police officers. And I want to know what happened with this police officer. And this is why it's relevant to my theory of the case, Your Honor. This is the link that I'm telling you, the prejudice if you don't give it to us. And and I just really feel like it's just been this sense of, oh, come on, she's always yelling for the same stuff, and I don't want to really know. And I think that's the power of the defense, frankly, is we have been woke and coming together on this across the country and saying, we're done. We're not going to put up with this anymore. And I think it's great that they call themselves progressive prosecutors. My feeling is they're doing what they finally should have been doing. And finally, they're on it with us, right? They're getting that the integrity of these convictions have been so compromised, and they look bad because Rebecca's office is coming and showing, look at all these wrongful convictions. So, I mean, I feel like I sound a little harsh, but that's kind of how I feel.
Well, it's not harsh if 44% of our cases involve the concealment of evidence. 44% of the nation's first 2,400 exoneration cases involve the concealment of evidence.
It's remarkable.
Yeah. Well, there's also a role that's being played here, or I should say related to this. There's a significant role that seems to be played here by the police unions. And there was a fair amount of discussion of that in the episode, and it's an issue that cuts across police misconduct of all kinds, right? I mean, the whole issue of the police union's role became more in focus during the last summer's events and George Floyd and all the things that came from that. People started thinking about what these police unions are doing, what their role is in protecting officers, not only who engage in brutality, but engage in additional conduct, I should say, like lying, that could impact just about any criminal case. So any of you have any thoughts or experiences in this very significant problem?
Well, it was interesting watching the dynamic in Philly between the prosecutor's office and the police department, and how they were at odds in some ways. Because in most places, I would imagine, I know in DC, the prosecutor's office and the police department are kind of in lockstep. And there's not really that conflict of the prosecutor's office trying to make sure that the defense has certain information, and the police kind of blocking them from doing that. Instead, it's pretty much a joint effort from both organizations, both the police department and the prosecutor's office, to try to prevent the defense from getting the information that it's entitled to, and the information that the defense would need in order to provide an adequate defense and to have a fair trial. And so often, both of those organizations work together to prevent a fair trial from happening by making sure that that information is not disclosed to the defense party.
I mean, it's kind of that feeling in court, right? When you have the lawyer coming in for the police union to get the record separately from the DA. So here you have another lawyer coming in fighting you on trying to get this stuff. And there's so many times you just want to turn around in the courtroom and go, but why? Why don't you want the truth? But just why? And it's so simple to me. And, I have to say at the end there, I kind of got chills with Krasner telling one of the chief deputies, and I think her name is Cummings, and I give them kudos. She's fighting. She's really seems to be fighting to get this stuff. But he said to her, no, she said, I think we can make a compromise. Remember at the end there? And he said, no. There is no compromise here. They've been doing this too long, and we're going to do it this way, and we're going to get this, and I'm not giving in on this. And that was pretty remarkable to me. And I don't know. I mean, we'll see how election goes for him, right? The next time around. I mean, that's the problem he has is, his constituency, and that last scene of the police union and the folks sitting out there, and, the very white crowd, frankly, backing the police union. It was really just striking. It was striking.
Yeah, I was also struck, by all of what you just said, but also just the fact that, when you look at the role of the police union contract in Pennsylvania, 70% of the complaints that are made by the public are based and that are actually substantiated end up being overturned or reduced because of certain provisions in the union contracts. And it's so striking to me to think about comparing the protections that the police have. like a guilty cop has versus an innocent civilian. Like when you really think about it, it's nuts. I mean, you know, our clients are like sitting in protracted, you know, interrogations late at night without attorneys, often, you know, petrified, coming from, you know, communities of color just being battered. And then you see police getting 48-hour cooling off periods before they even get interviewed about an incident. So it's just this unbelievable disparity. And just when you're thinking about that, even with respect to, you know, a cop who actually did something versus an innocent civilian, and just the union protections that keep stepping in to really just protect this process of secrecy.
Well, I think you mentioned it previously. It's not just the union contracts, it's the laws in various jurisdictions. California, I did a little bit of research for this. California passed a law in 2018 that exempted from or did away with exemptions on its public records statutes for reports of serious police misconduct, you know, substantial lying, you know, severe brutality, sexual assault on the job, only on the job, et cetera. And of course, the union immediately sought to, you know, file a declaratory judgment action that the law was unconstitutional, invalid, et cetera. And the California Supreme Court did hold it up. But I suspect, without, you know, being an expert in this field, that there are any number of states that have statutory protections that, you know, nobody can pierce, even the prosecutor, maybe a judge, but that's another barrier too, I would think.
A ton of interlocking laws that do this. I mean, it's, you know, the existence of, you know, these laws that, you know, they're largely public information laws that have carve outs when it comes to the police. That's in, you know, most of the states. And then you also have law enforcement bill of rights that add additional protections, and then, you know, union contracts. So all of these things are, you know, interacting and ending up with a completely closed system. And this is just very basic evidence that the defense deserves to have. And when you look at just all of the roadblocks, and they're just set on top of each other, it's extraordinary.
Another thing in the video that was I thought was very important is what they're doing at the Philadelphia prosecutor's office is much different than what they're doing anywhere I've ever practiced. And I say that because this fight that they were having is much different than, and I keep going back to DC because that's the example that I have. In Washington, DC, when you are trying to get any information pertaining to police misconduct or any bad police behavior in the past, the prosecutors literally fight tooth and nail for every single document to not be disclosed. And it is a constant fight, regardless of how serious or maybe not serious the allegations might be, or the charges might be, or the sustained findings of misconduct. It doesn't matter. They never want to turn anything over. And it begs the question, do they really expect a fair trial to ever happen if this information is something that they're actively trying to hide? And the other thing is that judges so often side with the prosecutors, and they determine that some misconduct or things that happened in an officer's past is not relevant to this specific case. And it's not really important, or it doesn't really matter, therefore the defense shouldn't get it. And when we do get information, it could be for a very serious offense, but oftentimes what we get is what they call source documents, which is literally a 1 to 2 sentence summary of what the incident was. So there could be hundreds of pages of documentation pertaining to the investigation of these officers. And oftentimes what the defense is able to get is just the summary that the prosecution themselves create, which is just a couple of sentences. And that's what we have to go on when crossing this officer at trial. And we don't get the information that actually exists. And it's just unfortunate because in my opinion, it's a clear example of prosecutors not really fighting fair and not really trying to have a fair trial, but instead just doing everything they can to get a conviction.
Well, in addition to needing the information or to get a fair trial, as we all know, you need the information as well to try to make decisions about recommendations, at least to your client, and decisions that the lawyer gets to make about the case. One of the most striking things that I heard during this episode was that in the prior administration, the DA's office if it found that a case involved an officer on the do not call list, which is essentially, you know, we know what that is, that they would rush to make early plea offers so they wouldn't have to disclose the information, because it is not clear. Let's put it that way. There's a split in the circuits right now about whether you have to make Brady disclosures to someone who is entering a plea, or especially at an early stage of the case. So have you guys had experience with instances in which there were, there was a push to get a plea that your client rejected, or for whatever other reason you later find out was being pushed because, lo and behold, there's a bunch of Brady material out there that the prosecutor didn't want to disclose?
Our biggest nightmare, right? So I think what happens to a lot of us, and I think it's practice around the country, is here's the standard line. If you go to preliminary hearing, all bets are off, and we're not making this offer again, and blah, blah, blah. Well, what that really means is I don't get to challenge the evidence. I don't get to learn about whether the police officer is not credible or not, or whether they have a long record of misconduct. What you're really saying is you don't have to prove your case. And my client has a constitutional right to challenge the evidence. So this whole, deals are off the table. And if you do this and if you do that, I mean, it just drives you crazy. But I know it happens around the country. And I know it happens to, when I was in the public defender's office, that's again, the strength of public defender offices, is because we kept track of this stuff. In the Colorado public defender's office, we kept track of the bad cops. We kept track of the hearings, and we were very united around the state in sharing that with other defense lawyers. It wasn't just for our office, but it was the benefit of the defense bar. And it became quite powerful. I will tell you though, in my state, we do have a citizen oversight board. And it's a pretty progressive thing in Denver, and it's in Denver, where that citizen oversight board monitors the police union and some of the things, Rebecca, we're talking about. It's not perfect, but at least it is something that has come in place, and it can be very powerful, and it can kind of push the prosecutors, Blair, on some of this stuff. So there are those kind of answers, but it's incredible to me how they do that push to us, and I've been practicing 35 years. So for me, it's a joke. I laugh at you because I know, what, that's not really going to happen. And I'm going to make your life miserable, when your case starts falling apart here, and you better offer something better, right? But still, that's just not fair. It's just not fair.
And it happens all the time. Lisa's so right. And it's a threat. They're essentially threatening you and saying that if you decide to move forward, and if you decide to actually seek justice, or try to seek more information, or try to just figure out what's going on with this case, we are going to withdraw any plea offers, and your life is going to be much worse, is a threat, because now you're looking at much more harsh consequences. And it happens daily. And it's just a matter of course at this point. It happens in literally just about every case at some practice levels. If you go forward with the prelim, then you're not getting this deal. If you try to go forward with the case and actually fight the case, then we will make your life much worse, and the consequences are going to be much worse, because any plea offer we make, we're pulling off the table. It happens every day, and it is very, very frustrating.
It's a critical point, because I think, on the plea end, I think it's hard for the average American to understand, that isn't doing this work every day, why an innocent person might plead to something they didn't do. And I just really want to hammer home the fact that it is a rational choice for most of our clients to plead guilty, even when they're innocent. We had a client from New Jersey, Rodney Roberts, and I'll never forget, he put it so poetically about the plea that he took as an innocent person to a rape. He said, I felt like I was saving myself and sabotaging myself at the same time. And, it might be counterintuitive for people to understand why someone might plead, but it is in fact totally rational to plead, when everything's stacked against you and you don't even know what evidence might be used against you. And your lawyer, this is their last chance to try to get you the best possible deal. I mean, you can see the pressures on everyone in this system when we have, incomplete information. And, you know, even when defense lawyers try to collect this information, as Lisa was just describing, that's just the information that they have access to. I mean, one of the problems too is that all these unsubstantiated or unsustained complaints, those never make the light of day, but they also tell you huge amounts about a cop's history. I used to investigate cops for the city, and I'd pull up the record of a cop and see 20 allegations of offensive language, which generally meant racist language. Most of them weren't substantiated because it was one word against the other. We were 23 years old investigating cases for the city. We couldn't find witnesses. We had a million cases. So, you know, it was one word against another. Our bosses were former law enforcement. So there were, you know, a lot of incentives to, you know, it was set up to not even end up with a ton of substantiated cases. So that's another reason why, you know, we need all of this information.
Right, right. And, you know, and Blair, on a positive note, I will say, I see defense lawyers doing the investigation on the front end that they should be doing. And it is so critical to me about everything that happens in a case. And if you go out and you're listening in your neighborhoods, the neighborhoods where our clients come from, these folks know the reputation of these cops in the community. And you got to listen to them. So I think what happens to us, you know, we become desensitized. Oh, yeah, you're telling me this, you're telling me that. But if we start to really listen, it's pretty amazing that even though we may not have the documentation in the paper, they're right. They know the bad cops. They know the cops that are coming in and beating up folks in the neighborhood. And I think that is critical to us. And we can unearth a lot more listening to those folks.
Yeah, and at offices like the one you were in and in the practice you currently have, and in places like the Public Defender Service and a number of other public defender offices, you know, you do have the resources to do more extensive investigations than you do in a lot of other offices. But the importance of disclosure for the vast majority of public defender offices or court-appointed counsel from the prosecutor is critical, because people just don't have the time and resources in some offices to go out and do that. And in any event, they're not going to have all the information that they can get from the police themselves and the prosecutor's office themselves. I'd like to shift this a little bit to do not call lists, because conceptually it actually is different. It's related to prior police misconduct, but it's different. I mean, you could have a DA's office could have a practice of disclosing everything he knows, and even everything that the police knows, to defense counsel in cases where a police officer is going to be a witness or was involved in the investigation, and could take the position, well, you know, if the defense wants to use it, they can try to use it. They can ask the judge to admit it, and, you know, the judge can admit it or not admit it. But we're going to call the officer and let the chips fall where they may. What's wrong with that approach, if anything? In other words, still call the officer, don't have a do not call list, but, you know, disclose the information and see what happens. See if the judge allows the defense to use it or not, and see what happens in the trial.
Yeah, put it on our backs, right? It's always, the onus is always on the defense, right? I mean, it's, again, really? So, I mean, I think, you know, that's what it appears is correct, Blair. And I think, you know, so then what are we doing? Do we then shift that to the judge? I mean, make it the judge's problem? We know this. I'm telling you this information. This is, again, why it's relevant. This is the prejudice to my case, making that record. And Judge, I'm asking you, you take a look at this. You tell me why we shouldn't have, and really maybe shifting it to them, because, you know, you get tired of it always being our fault when we're trying.
And it's also a bit frustrating because it's always us, as Lisa was saying, that's always asking for something. And we seem like the ones who sometimes are unreasonable. Oh, you're not satisfied. You want more information. You want this and you want that. When all you're asking for is the information that we are actually entitled to. And taking a step back, when you think about police misconduct and the fact that in so many legal arenas, it is acceptable to not disclose that, it just doesn't make any sense. Police misconduct should be something that is available to the public in every single case, and regardless of what it is, And that's because police officers are simply regular people that are given extraordinary power. They have guns and they have badges and the power to arrest. And when you give a group that much power, it is important to have some type of oversight and to have some type of accountability to the public. So when you have police officers that are doing these type of things and engaging in this type of misconduct, for prosecutors' offices and kind of for the legal arena as a whole to accept that that is going to be hidden. And it's not only not going to be disclosed to the defense, the general public is not going to know about the bad things these officers have done. That is a terrible stance to take. And it's a bit surreal when you think about it. Why? If you're a police officer and you have this power and you are policing communities, why should those communities not know about different things that have happened in your past and misconduct that you have engaged in? It just doesn't make any sense, but it's a common practice and it's something that the legal world has accepted in so many places. And it's very frustrating and problematic.
I couldn't agree more. I mean, it's not, obviously just failing to disclose evidence in an individual case is already horrifying, but it also, keeping this secret prevents any accountability whatsoever. It just, it is why, having transparency in these, police misconduct, police disciplinary histories has to be public. It has to be in order for there to be any true accountability. Otherwise, you're basically relying on the police to police themselves. And we know, in New York, when we made, police disciplinary records public back in June, the first thing the New York Civil Liberties Union did was they FOIA'd all of the, civilian complaints just in New York City. There were, almost 300,000 of them. But, we started to compare our known wrongful conviction cases to the detectives listed there. I looked at the detectives in the Exonerated 5 case. One of them had, 37 complaints of basically, and it was all totally race-based complaints, 37 of them. Most of them hadn't been sustained, but that certainly tells a story. We didn't know that until now. I mean, it was just unbelievable. I mean, there were the 10 primary detectives that racked up over 120 complaints. It was all secret.
What I was trying to focus on was the concept of do not call lists, which is, as I said, somewhat distinct from disclosure. You could have all the disclosure in the world. The prosecutor could or could not have a do not call list. And there was some discussion within the DA's office in Philly about, what qualifies someone for a do not call list. And I'm interested in the views of all of you on whether DAs should have do not call lists. I assume everyone's going to say yes, but if so, who gets on that list?
I mean, the do not call list, what are you saying, that it's your work product? So you have a do not call list and that you keep the track and you don't let the world know about what the do not call list looks like and how do you use it, how subjective it is. I think they said 3 categories, Blair, where it was violent, untruthful, and other, which I was like, what is other? I can imagine what other is, but
right.
That's where you get into this subjectiveness, right? And control issue and authority. And so to me, the do not call list is they just shouldn't be around. These are officers that need not be in law enforcement. And what appeared to be very frustrating to the DA's office is they have no power to sanction, right? That was very clear. We don't have really any power here. We don't have to call them, but it seems to me if you're not calling them and they're still part of what's going on in arrest, and what good does that do? It's a meaningless thing to me. And so it's a fiction. That's how I put it. It's a fiction.
And there was a gentleman in the video who made a comment that I fully agree with. And he said, if a police officer has conduct so egregious that he can't take the witness stand and testify, then how is it that same officer can still remain a police officer out policing communities? It just doesn't add up. If his behavior is so bad you can't put him on a witness stand, he is not the person we should entrust with the power of a police officer, because they do have such power over the community, and the decisions that they make can completely alter someone's life. And you're still allowing them to have all of that power, but at the same time saying they have engaged in conduct that has been so egregious that they cannot take the witness stand. It's obviously something that doesn't make any sense.
Right. To me, it doesn't seem like a leap if somebody has, perjury on their record that they weren't fabricating evidence, right? I mean, and they're still operating as a cop. So I think that's, I think that's really the key point here, right? I mean, I do think, look, I mean, I think any tool that can be used is good, but I mean, but it sounds also to me like, and I'm not litigating these cases, but, so you might have someone on a do not call list, but the other cops and, connected to the same investigation can be called. So I don't know how that really quite plays in a particular case.
Right. Exactly. Blair, what I thought was super interesting too along those lines is when you had the Philadelphia public defender in the room about the kind of, which cops and which disclosures, and I think it was, again, the Chief Deputy Cummings, and he said, all of them ought to go, right? I remember that. I mean, it was very interesting to me because I thought, does the defense compromise here? She said, well, how about the cop with the DUI? And so your defense part, at least for me, maybe I'm wrong, but I'm a defender. So then I was like, well, you should give second chances, and it's a DUI. So maybe that cop ought to get a second chance. I mean, it was a very interesting point, right, for all of us. And he was saying, I'm not giving you any ground at all here. Absolutely not. So I don't know what the defense position is going to be around the country on that, right? I don't know. What kind of crimes can we let them come back? What kind of things will we forgive them on?
Right. I mean, if you have a system where there is full disclosure, which I know we will never get to, but let's assume for the sake of discussion, there is adequate disclosure of all police misconduct. A prosecutor will have to make hard decisions about whether, if they use it, whether to create a do not call list, and if so, who to put it on. And Lisa, I think you hit the nail on the head quite well in that, some of us who have been defense lawyers forever, our instinct is, a DUI off the job should not preclude someone from being a cop for the rest of his career. Not everybody's going to agree with that, but many people will. So I think that some of these prosecutors who go down the road of this do not call list are going to have to make and have had to make difficult decisions like that. So there was some relatively recent federal legislation, which probably is not going to make that much difference, but in the President Trump actually signed in October of 2020 the Due Process Protection Act, which requires in the federal courts that the judge enter an order requiring the government to comply with its Brady obligations, which it has to do anyway, and also outlining the potential consequences of failing to comply with that. Now, I have not had an active federal criminal case at that stage since the fall of 2020. I'm not involved in any of the Capitol protest cases, for example. But I'm curious whether any of you have had experience with that or other reform measures. I hesitate to call that a reform measure because it's just basically telling prosecutors to do what they're supposed to do anyway. But what have you seen in the Brady or even more broadly discovery reform area in the last few years?
I think there is a movement towards open file discovery. I think it's the single most important reform, if we're calling it a reform, that we could put into place for sure. New York State, I mean, we spent 40 years trying to change our discovery framework. Defense lawyers were getting witness names, witness statements, and police reports on the day of trial. So, that has now been completely revolutionized. And it's, I've spoken to a lot of my defender friends who say, it's a whole new day. We're getting so much stuff and it's a problem that we'd like to have. Thank you very much. But, just going through hours and hours of body worn cam footage and, but that's what the defense deserves. And that's what we need. So I think, look, they're standing Brady orders, compliant. Look, anything that helps with compliance is a good thing. But I think kind of limiting it to Brady and putting sort of letting the prosecution have discretion about what favorable evidence is just an inherent conflict, because they're both supposed to hand over evidence to the defense, but also win their case. When you have open file discovery, they're not making calls about what favorable evidence is. And there's evidence that the defense might believe is actually favorable, that, a prosecutor could overlook. And those are in the instances where, there is no misconduct there. They just don't know. So why are we allowing this discretion to happen? Why not just have it be open? So I would say that's the single most important reform. And we are seeing states more and more. I mean, I'm seeing this in state houses around the country where there is now consideration of open file, or they're putting together task forces to really look harder at this issue, because it's just unbelievable. If you have 44% of 2,400 exonerations involving the concealment of evidence, we have a big problem on our hands.
Yeah, I mean, look, I'm sorry. Go ahead.
No, go ahead. Go ahead.
No, in terms of the memo, Blair, I haven't had a chance to use it because of COVID, frankly. I mean, everything has been delayed. Most of our trials have been delayed and all of that. But I'm actually looking forward to not only citing those memos, but a number of memos that came out of DOJ under Trump, and, on departures and reconsiderations and bringing back folks. I mean, things that have never happened before. We'll see how far that goes. I think all of us have had the experience of citing, these memos that get no traction, frankly. And it just remains the same as it always has. So I'm hopeful maybe that will make a difference. I don't know if it will be undone before it can help any of us, right?
And I'm in the same position as Lisa, where because of the pandemic, since this has kind of come into effect, I haven't had an opportunity to use it. But I also agree with what Lisa's saying, that a lot of these things don't really gain traction. They sound good, but in reality, they a lot of times don't make much of a difference. I could be a bit pessimistic, but I think history has kind of made me that way in terms of these issues. So, we hope for the best, but I can't say I think that it's going to create a major change. One thing that is true, though, is the narrative around the criminal justice system, obviously, the last couple of years has changed. And I think that prosecutors are a little more concerned about getting getting their hand caught in the cookie jar with some of these things. And I think that has led to them turning over information a little bit earlier and complying with what their legal obligations actually are, because now they realize that there may be consequences, and not even, I think, so much from the judge, and the consequences will come from the judge, but it's more so the public narrative has shifted to where they feel pressure. And I think judges actually feel a little more pressure now to actually make prosecutors comply with the obligations that they have.
I do think that federal prosecutors generally, and admittedly, most of my experience in recent years has been in document intensive cases in the federal courts, often what we'll call white collar crime. But I have to say, because of concerns, or for whatever reason, but I assume in part because of concerns about their reputations being besmirched with a finding that they committed a Brady violation, there has been a trend, at least in those sorts of cases, and you can put aside for a moment the problems with having a two-tiered system, okay, one for business crimes and the other for street crime, okay, but putting that aside for a moment, at least in those cases, which are ones that I have more recent experience with, prosecutors often do, give you just about everything. Not always. It differs from place to place and differs even within the Justice Department, but 302s, all the janks, everything at a fairly early part of the case. And I think it's for a variety of reasons. One is because of the concerns that I've just expressed, some because of at least an incremental greater sensitivity in Brady. And also because, there are subtleties in some of these cases, especially where there's huge quantities of documents and lots of witnesses interviewed that they don't want to be making the judgments for about whether this is exculpatory or not. And why that approach can't be applied across the board, I don't know. But
because they're human beings. I mean,
yeah.
so I don't disagree with you, Blair. I think in the federal system, it is not as bad, but I also think it depends on the nature of the case, like you've suggested. I think that it depends on the defendant. I think it depends on the race of the defendant. MS-13 cases, I don't know if they're going to treat them like they're going to treat my white collar client, right? I don't know if they're disclosing the same information, because I got some bad actors that they are perceived as very dangerous. Those are the cases where they withhold. They got a lot more to lose in those kind of cases. And so I think it varies even in the federal system. I know in the state system, I mean, you know, I was shocked in New York, like Rebecca said. I'm like, but it's New York. How could they not be giving us discovery? And it's changed in January. I get it. But I was like, what are you talking about? But everybody talks about Louisiana and Arkansas and Alabama. The South is so bad. Well, that's not necessarily true. We know you can go to, you know, New York or Wisconsin or my state. California has more people on death row than any place in the country. So, I mean, it's very interesting. And I think those factors come in, Blair, and that subjective part of them getting to make that decision based on their perceptions, their implicit bias, what resonates with them. That's the scary part, but that's the human part. So I don't want it to be robots making those decisions. And that's when I realized that's my job, to make sure you know you got those implicit biases and everything else in making those determinations. So, and the judge, letting the judge know the same thing, right?
Right. So this is a somewhat broader question, but I'm very interested in all of your views on this concept of progressive prosecutors. I mean, Larry Krasner is just one of an increasing number of people who call themselves progressive prosecutors. We have a couple in the DC suburbs, in Fairfax and in Arlington. They certainly are progressive compared to their predecessors. You know, we have St. Louis, we have other jurisdictions as well. What are your thoughts about this trend?
I mean, I think it's certainly encouraging. I mean, I think I will echo what Lisa said earlier, which is that, you know, it's kind of a tough day when, you know, being progressive is, you know, just saying we're going to really take our obligation seriously. So I think, you know, I do think it's encouraging. I do think, you know, obviously I think the proof is going to be in the pudding in terms of, you know, what are those offices actually doing in terms of front end policies? You know, I mean, obviously many have conviction integrity units. And by the time that's in play, somebody's often been behind bars for many, many years. So I think, you know, I think the true measure of how strong this movement is going to be is what are the front end policies that they're going to be putting in place around charging decisions, around bias, around all, you know, all of the things that they could do to really reduce the footprint of the, you know, the criminal legal system. So I think that's where the measurement's going to come in. And I think, you know, certain individual offices are really doing extraordinary things right now. And I think, you know, and then I think in other instances, you know, I mean, we see this within conviction integrity units. Sometimes they're robust and they mean it. And sometimes we see, you know, it's nothing more than sort of more of a, you know, public relations effort. So I think it really, it's going to come down to sort of the data, what we see coming out of those offices.
Mm-hmm. Yeah, I agree. I mean, look, you have Jason Williams in New Orleans, who's, you know, who came in as a defense lawyer, and he's doing some incredible things. Gascon, Chesa Bodine in San Francisco. And I mean, Kim Fox, I think it is. I mean, you got some Mobley, some really great people. The problem is, you know, particularly for these African-American DAs, they're getting so much pushback politically, and they're targeting these folks, and they're just giving them hell on changing the system. And that's where I'm torn, because I want to support them. I want to see change. Obviously, what's good for my clients are what matters. And I see a lot of us going to the other side. That's a harder one. I get a lot of stomach aches from that. But I get it, right? I get it. And so there's this new, and they talked about it in the film. I think it was the juvenile chief, Listenby, who was just terrific, you know, and he had the old guard progressive and the new guard progressive, right? And I just thought that was such an interesting interaction because they weren't on the same page. And so that's that tension and all of the things going into this new changes, it's going to take a while, and it'll be interesting to see where it goes. Is crime going to go up? Are stats going to change? Like, you know, Rebecca's right. It's the data, the data.
And that was a very interesting scene, Lisa, when you had the old juvenile prosecutors who themselves, before Larry Krasner was elected and put in office, they were the progressives. They were the ones fighting for it. Because presumably the people who were not progressive are no longer there. And now they're being looked at, and there was a scene with two juvenile prosecutors, and they were talking about the fact that someone maybe has spent their career there and they thought that they had been doing great work, and now this new administration comes in, is kind of telling them, well, you're part of the problem and not part of the solution. So it is very interesting. I think it's all relative when it comes to progressive prosecutors. It's all relative compared to the people that they are replacing. And the challenges of kind of going over to that side, it's not as if just because you become the district attorney for a certain city, you can instantly go in there and make changes. And I think the video did a great way of illustrating that. There's a system that is in place. And even if you are at the head of the office, you are still fighting against a system that has existed for decades. And it's not easy to make change. So while in some ways it is encouraging, again, I don't want to sound pessimistic, but it's tough to really think that changes can be made very quickly or immediately. It's a long process, and there's so much pushback against any change from that side. It's kind of a wait and see approach. We can hope, but we have to kind of wait and see what happens.
We've been waiting a long time now.
We are nearing the end of our time. I wanted to make sure I made sure everyone had the opportunity to say anything else, talk about anything else that we haven't talked about so far. Any other ideas or comments you want to share?
One party in the legal community that wasn't really touched on in the video that I think it's important is judges, the bench, because so oftentimes police misconduct is covered up by the prosecution, or the prosecution protects the police in a lot of ways, so the public never sees, the defense never sees. I think a lot of times the judges kind of operate the same way in regards to the prosecution, because as a defense attorney, all you can do is appeal to the judges to get this information, appeal to the judges to make the case fair. And oftentimes the judges have, they do things that are pro-prosecution, or they are a party in kind of this police misconduct and other things not being disclosed. And I think that oftentimes judges don't get the same type of scrutiny that police officers have recently, and prosecutors even more recently have been getting. But I think the bench is also a party that needs to be viewed and that needs to be scrutinized when looking at this issue.
And wouldn't it help if there were more former defenders on the bench than just people? I forget the stat right now, but Cato Institute has actually done a terrific job of sort of tracking the numbers. And it, all of us who have practiced on the defense side understand it. It's a high majority of judges who are either people who are federal prosecutors, or they represented the government or the other side, even in civil. And it's really the same thing. So you have a majority of people sitting on the bench trying to decide, assess credibility, assess who wins an evidence argument, assess whether there's a misconduct in a case, and yet the vast majority of them are people who have experience from one side and not from the other, and I think that shows in America's courtrooms, and it's going to keep showing until more defenders get on the bench. Any of you want to be judges?
Why? It's not fun. What we do is more fun.
Absolutely.
All right, well, thank you, everybody. You guys helped us have a really terrific conversation this evening. I really appreciate you giving up your time on a Sunday, particularly for Lisa, who's actually in a different time zone and it could still actually be outside and enjoying what looks to be beautiful weather. And everybody else is winding down on their Sunday evening. Thank you all so very much. And be sure to join us on April 11th when we resume our series for part 3 to try to explore how to transform prosecution. Thank you, Blair, Rebecca, Lisa, Kevann. You were great.
Thank you.
Have a great night, everybody.
Thank you.
Bye-bye.
Bye-bye.
Bye.